Morning. Welcome. I am Rudolph D'Souza, your host today's webinar by MyNation Hope Foundation. Thank you for being with us today. We appreciate you joining us on every Sunday on different topics related to law. We simplify law and we are giving webinar to our members and general public. We have same type of webinar on different topic. If anyone want to know which we have not covered so far, you can post it in our chat window, or we can or send us as WhatsApp message also. के बाद so we are continuing with our legal topic. Dr. Vikas Singh will continue with
Okay, thank you, Rudy. So today we have two topics to discuss. One is tax evasion petition and one is interrogatory. The webinar on tax evasion petition will given by Mr. Balamurthy. Mr. Balamurthy is working as a manager in MNC at Hyderabad. So first, I would like to welcome Mr. Balamurthy to start his session. Thank you.
Thank you. Yeah, my name is Ramanamurthy myself. First of all, I would like to thank MyNation Hope Foundation giving this opportunity to share my knowledge in this tax evasion petition. I'm starting. Tax evasion petition procedure and hurdles PPT. In case the women's party claims that they have given a huge amount as a dowry, and if they don't have income support to such items, then you can file tax evasion petition, followed by RTA and TEP to income tax department against fill and dowry givers. The basic idea is to find out how they were able to give so much dowry if they do not have suitable income. In case it comes out from RTA that they did not have suitable income, then we can considerably. Previous years.
Uh, Ramana sir, we lost you on basic idea. Can you start with the second paragraph?
Second point, basic idea is to find out how they were able to give so much dowry if they do not have suitable income. That means the source of income. So they don't suppose they don't have supposed to the source of income. How they have given the basic idea. Okay. In case it comes out from RTA that they did not have sufficient income to give the said amount as dowry, then their case will weaken considerably. If they still insist that they give that much dowry, then they will have to explain to IT department what are their sources of income and why they did not disclose that income in that and previous years. This is the basic idea. One is the sources of income. Okay, if they have sources of income, why they have not informed to IT department? IT rules are clear that if somebody hides income to avoid income tax, they have to pay back income taxes along with interest for all these years, and also penalty for evasion of income tax. Any questions? Okay, I'm moving next slide.
Yeah, we don't have any questions so far. Yeah, you can actually.
Yeah, what is meant by TEP? Tax evasion petition. A complaint letter to income tax department with proof to investigate the revenue loss to government exchequer because of such evasion. Why TEP? Mostly wife always give the list of Sridhan three to four times from the actual list of Sridhan. Huge amount of dowry in her complaint. So we have the legal tool for this. We should complain in the income tax department for verifying that they have declared that much income tax or not. Okay. If they have not declared that much income, then recover the tax with some penalty. but very few people go to income tax department to ask for verifying their income. When to file TEP? If your wife do the false allegation in DV case affidavit or in 498 FIR about huge amount of money spent in marriage and treason or dowry or exchange of money in our marriage. If your father-in-law has disappropriate assets with respect to his income, TEP is possible. You have to show undisclosed income, unaccounted flow of cash, unexplained expenditure, etc. to the file. If the value of the furniture, gold, cash was not proportionate to his income at the time of expenditure, you can file TEP. Any questions?
Yeah, we have one question.
Yeah.
Does seeking info as RTI regarding dowry be considered as even dowry being taken during trial? Like, if at all, if the husband side actually files this RTI, will that be negative to them?
Okay. Uh, Hello.
Hello. Yeah,
Yeah.
Murthy.
Yeah. Come again.
If at all, if the husband side actually files an RTI asking the persons whether
Mm.
there has been a dowry given at the time of marriage, would
Okay.
that be considered negative to them, because it will also be considered they gave dowry and the husband side has taken dowry. So for the family of husband, because they have taken dowry, will there be any demerits in their trial in 498 or DP Act?
In that there is no demerits. We are just asking just to opponent the source of income and if they paid the taxes or not. That is what.
Okay. Okay.
Okay.
Yeah, we are only asking that you said like these articles have been given as gifts or dowry, whatever it is, but that will be actually considered later. Where did you actually procure these gifts? These gifts are actually like high
Yeah,
Yeah, the
financial
complaint.
assets. So for
The complaint says always
yeah,
3 to 4 times.
I'll clarify this answer. Right. A person, let's say father-in-law, is having an income of rupees 5 lakhs per month, per year, let's say. So if he claims to give a dowry, if wife claims to give a dowry of around say 50 lakhs, okay. So is it possible? No. In that case, you will be filing.
TEP.
Okay. So he'll have to justify to income tax department from where did he get the income,
Yeah, the source of income.
the source of income. And
Most of the time, what they are saying, they took it from relative. Okay, my auntie gave, my uncle gave, my kaka gave, chachi gave. They say like that. Okay, and they also come and give the statement that we gave, but there is no transaction. They are not giving like bank transfer, nothing. They are saying, oh yeah, we gave it. It's she is for us like daughter, so we gave. Most of the situations happens like this.
yeah, but in that case, we can ask in the RTI that what was the outcome of the TP? What was the outcome of the investigation, and not the income tax form 16 or in some income tax report of them. Okay, so if he says that the relative has given this amount of this relative has shared this amount of money to him, so we can also go to file a TP against the relative as
Yeah,
well.
we can
Based
pull
on
the
this, yeah,
we can pull
we
their
can pull
relatives to
everybody.
everybody.
Yeah, we can pull everybody written in that report,
Yes, correct,
mentioned in
correct.
that report.
TEP to file TEP, it should be 15 lakhs. Okay, they will say they will come
Yeah.
5 or 10 members and they say we give 5 lakhs. Okay, you cannot file TEP there. Okay, they know all the tricks, how to twist it. Okay, we cannot go after every relative. Okay, we can file only with the father-in-law because he is showing or she is telling her father gave 50 lakhs or whatever. Okay, This is the actual scenario in real life. I see in many cases. Many relatives comes and they claim we gave. Okay, we gave our
Okay,
old
so
gold. Okay.
in that case, we also can drag the relatives in court for their
Yeah, yeah.
witnesses.
They will be the part of it. They have to justify. Okay. Anyway,
Yes.
TEP we can file only on father-in-law because he is the one person saying he gave. Bala, you can continue.
Yeah. So
Yeah,
in
yeah, I'm continuing. What are the task before filing the TEP? Get the certified copy of the complaint, whatever it may be. It may be DVCR, MCR, 498 AFIR. Get the PAN number if you know. Okay, if the PAN number is not available, I will cover in the next slides. Prepare the proper application. The application should be in a short and what we are supposed to informing that should be there in the application. Get the address of income tax department in your area. Okay, what documents required to file the TEP? TEP application format is available on below link or in MyNation documents. Is actually is there TEP format is there in MyNation document. DVC case or CRPC 125 case affidavit or FIR copy of 498 or any authentic document as per Evidence Act, where your wife admitted that they spend a huge money in marriage, dowry or sriza. What are the grounds for filing TEP? If you have a FIR copy, DV copy, bills of marriage expenses claimed by opposite party, wherein they have mentioned huge amount, bills of marriage expenses claimed by opposite party. If you have any detail wherein the have mentioned a large amount, better to have more and more information. For example, their bank accounts, properties also. I don't have PAN number of father-in-law. How to file TEP? There is no need to no need. Don't have even the you do need to have a PAN number details of file to TEP. Just give the full name and address details. That is enough to file the TEP. How much time it has to take to resolve the query under TEP? Generally, it will take 1.4, 1.5 year to 3 year, but the various RTAs we can raise accordingly. We can get in within a 1 year. Any questions? Hello? Hello? Hello?
No question. You continue.
No, no,
Continue.
no
Yeah,
If
yeah.
question.
questions are there, we'll interrupt you and ask you. Don't stop. Okay. Keep on.
Okay,
Continue.
fine.
If there are questions, I will actually interrupt and ask.
Okay, thank you. What are the advantages of TEP? For sure, this will go against the 498A DV family as it will expose their false allegation. You can screw the 498 family royally without this legal cruelty tool. Okay, can handle without legal aid, no lawyer, no expenses. Okay, file numerous RTAs based on the opponent's profile and fast track the TEP investigation. That is what previous slide I told you that you can call the investigation officer with investigation report using witness summons in our cross statements. Then all the false allegations will be nullified. Your case will become weak. Then you will have an upper hand. That is what basic idea of the advantages of the TEP. Okay, what are the disadvantages? Disadvantages will not work when less amount is claimed as dowry. Actually, we know the government machinery how to work. They will take only above 15 lakhs and 1 crore, 50 lakhs like that. Needs to cope up with the time delay for RTA replies from government departments and information commission response for appeals. Government machinery may not work with expected efficiency. Very indirect method of attacking the opponents. Where should I make a complaint? To the Chief Commissioner of Income Tax of your particular state with a copy to DZAT Investigation Income Tax Department. Secondly, to a member investigation CBDT Department of Revenue, Ministry of Finance, North Block, New Delhi. how TEP strategy work.
Uh, we have two questions.
Yeah.
One question is, if the petition only mention huge amount given as dowry, how can
Okay.
we file? How can TP help?
Yeah.
Means they didn't mention the amount. They just say कि huge amount is given as dowry.
Okay. In that case, actually, the particular amount should be there. Then only TEP can help. Because the
It's a
government.
vague allegation. Let me answer this. It's a
Yeah,
vague
vague allegation. It's a vague allegation, we can say.
Okay. The another question is कि if the mentioned amount is less than 5 lakhs in FIR, what's the alternative method to file TP?
Okay, the basic funda is government machinery work on huge amounts only. They will be concentrated on huge amount. But there is a chance, even though if opponent don't have income source, we can file the 5 lakhs, even 5
Okay.
lakhs also.
There is any other method which we can use beside TEP?
Yeah, we can use. There are so many RTS regarding. One is the civil supplies method. That is different from TEP.
Okay.
TEP
Can you explain a little bit?
about civil supplies.
Yes.
Okay, suppose opponent is in a BPL, that means below poverty line. They are using ration, getting the food grains and all through uh, FOC, fair fair ration shop. Okay, in that case, we have to find their ration card number and send a district collector and MRO. They are in the BPL. They are using BPL card. How they are giving such amount? We can file like that.
Okay. Thank you. Continue.
Okay. How to strategy work? Okay, that is completed. How TEP strategy work? Ask for the detailed investigation report of the proven TEP. That they will cover later. Submit the same in 498 code, questioning that IT department also not able to find source of income to pay such a dowry. The case definitely is a false, as it has been investigated by a party having no interest, and that to government department. To submit to the 498A court that the family is itself dishonest by nature, and hence has filed this 498 for encasing money using law as an extraction tool. Okay, format of TEP application. In MyNation website, there is a document, sample format also available. Okay, what will happen to 498 family if you are able to successful file the TEP? One is they need to pay tax of undisclosed income with penalty, with years of penalty. Okay, they need to disclose the source of income from unaccounted amount. Okay, plus penalty which cannot be less than 100% of the evaded amount and not more than 300% of evaded amount. In that, we are having one of the benefit, we will get the 10% prize money. Okay, following precautions should be take care before filing the RTA and TEO. Your right application is need to be proper and short. You should have provided grounds for disclosure of the said information by stating that the truth and justice are the superior most public interest. It should not be a individual interest. It should be a public interest. Subjects and the denial of information can hamper your liberty and constitution right under Article 21 regarding the right to live with dignity. Moving to next slide. You should file the multiple RTA with short questions. While asking information under RTA Act, care should need to be taken as there is no need to ask income tax return. This is a very important thing. If you are asking income tax return, that is come under personal interest. Instead, ask for whether the income shown in below or above the one claimed in your FIR or CEWSL complaint, then it will be easier for them to reply, as here you are not asking return. neither you are asking amount. You will get the information which will be sufficient. Also, to ask for how many times notices were sent. If one of the notice is not compiled, then it attracts penalties and so on. How to get the output of TEP? Output of the TEP has to be discussed. That will be, we will discuss it in later slides. What is the term tax evader? The tax evader is the person who has not submitted required income tax as per law. Step and process of TEP. Fill a TEP in income tax department. Send RTA to find get status of TEP and TEP. If you get the negative response of the RTA, the CPO denied the information requested citing section 81J and 81H of the RTA Act 2005. Those examples I will discuss in later slides. Next slides. Sent first appeal to concern office. You will get some response from form of first appeal and RTA as well as in the RTA response. Ask the detailed report in our case using CRPC 91 or witness summons. Get the final report from the authority.
We have one question.
Yeah.
Why RTI is mandatory for TEP?
Yeah, I told you, government machinery will not work properly. We have
No.
to.
Question is ki why he need to file RTI to get information about TEP?
Yeah, RTA means once we
Means he want to know ki if there's some other option available which from where he can get the information about the TEP other than
yeah,
RTI, I think.
yeah. That is I will discuss. There are some other slides I will discuss later.
Okay.
I'll elaborately I will discuss later. Okay.
Okay.
Yeah, problem with the TEP. One major hurdle is statutory elimination of TEP for 6 years. More than 6 years olds, the department are allowed to not investigation. Apparently, they carry the records only 6 years back. Hence, filing TEP as soon as possible is the best thing to do. It returns can be opened for 4 years if the amount realizable is less than 1 lakh. IT returns can be opened for 6 years if the amount realizable is more than 1 lakh. Okay, what are the different categories of TEP investigation? Z category. All personal complaint are considered like TEP against 498 family. This is a slow category. All the businessmen with huge turnover, this is a medium priority. X category. All major fraud, this has the highest priority. What is the judgments referred by income tax authorities to reject information and RTA Act 2005? Yeah, this elaborately I will discuss in a later slides. This is, I'm moving next slide. CAC judgment which you should attach with the first appeal. Yeah, I have given citation for that. As the appellant has provided information relating to tax evasion, the CPO is directed to inform the appellant to whether the information provided by him was true or false, and to disclose the board outcome of the reassessment without divulging specific details once the process is completed. Okay, where can I complain if income tax officer is not taking proper action on TEP? You can come. I have given link for that. You can very well lodge the complaint using this link. Okay. How can I show larger public interest in my RTA against TEP? Firstly, tax evasion is a crime and knowledge is needed in public domain. It is different than asking IT returns. Secondly, the information required to prove innocence of few people. What happens after filing TEP? Income tax department issue a notice under section 142 of Income Tax Act. The parties need to respond within 1 month. Otherwise, there is a penalty up to 10,000 for disobeying of court notice. But no one cares as income tax officer never implement. The copy of the summon has a clause which read as follows. Without prejudice to the provision of any other law for the time being in force, if you are intentionally omit to so attend and give evidence or to produce the books of accounts and or documents a penalty for a sum which shall not be less than 1,000, but which may extend it to 10,000. For each default or failure shall be imposed upon your under section 272A of the Income Tax Act, 1961/37(2) of Wealth Tax Act, 1957. If required, ITO can issue summon under section 131 of the Income Tax Act, 1961, wherein opposite party will be directed to present himself, herself before ITO. Any questions?
No, Murthy. Yeah, you can proceed.
Yeah, I'm going one judgment highlights. Girija Verma and Bhagat Singh for the petitioner, Sonia Mathur for the respondent. I'll right now discussing about highlights of the judgment. The writ petition filed by the respondent number 1 herein paying for quashing of the order of the Central Information Commission with a direction that the information sought by the respondents under the Right to Information Act 2005 should be supplied immediately. Actually, what happened, the respondent number 1, in order to enable him to defend the criminal prosecution, approached the income tax department with a tax evasion petition, so and so dated 24/9/2010. He lodged a tax evasion petition. However, the department summoned the wife of the respondent number 1, present her case before them. The respondent number 1 made a repeated request to the director of income tax department investigation to ascertain and know the status of the hearing and TEP proceedings. Having failed in his endeavor, the respondent number 1 moved an application under the Right to Information Act in November 2005, as per 2005, praying for the following information. This is what, why should we file the RTA? These are the this thing, fate of the petitioner complaint. That means we have to know the status of the petition. He filed on so and so date 24/9/2003. What is the other source of income of petitioner? Wife Srimati Saroj Nirmal, then from teaching as a primary teacher in a private school. What action the department had taken against Srimati Saroj Nirmal after issuing a notice under section 131 of the Income Tax Act 1961 pursuant to the said tax evasion petition. The aforesaid application filed by the respondent 1 herein was rejected by the public information officer designated under the act by the income tax department, as against which an appeal was filed before the appellant authority, which too rejected the request to have access to the aforesaid information. As against the said order of the appellant authority, the respondent number 1 filed a second appeal on 1/3/2006 before the Central Information Commission, praying for setting aside the orders of the respondent number 2 and 3 in the writ petition. The Central Information Commission, by an order dated 8/5/2006, allowed the second appeal and set aside the rejection of information. However, it was directed that the report should be disclosed only after the entire process of investigation and tax recovery, if any, is completed. The appellant department has accepted the aforesaid order of the CAC, and therefore the said order of the CAC has become final and binding. However, the department has not disclosed all the information in terms of aforesaid order on the plea. That notice under section 148 of the Income Tax Act have been issued, but no final assessment orders have been passed. It is also stated that only after recovery of taxes, if any, details could be furnished. The learned single judge considered the pleas raised, and thereafter it was held that no reason has come out as to why the aforesaid information should not be supplied to the respondent number 1 even at this stage. The contention and defense based upon 8(1)(I) was rejected. The said direction and findings rejected the plea under section 8(1)(I) to disclose information has not been challenged by the appellant. Apprehension should be based on some ground for reason. Information has sought for by the complaint and not the SC. Nature of information is not such which interferes, which the investigation has helped the SSC. Information may help the respondent number one from absolving himself in the criminal trial. It appears that the appeal has held back information and delaying the proceedings for which the respondent number one felt aggrieved and filed the aforesaid writ petition in the court. We also find no reason to why the aforesaid information should not be supplied to the respondent number one. The grounds of appeal, it is stated that the appellant is ready and willing to disclose the records once the same is summoned by the criminal court where proceedings under section 498A of the Indian Penal Code are pending. If that is the stand of the appellant, we find no reason as to why the aforesaid information cannot be furnished at this stage. The investigation process is not going to be hampered. It has not explained in what manner and how information asked for and directed will hamper the assessment proceedings. Therefore, no prejudice would cause in any manner to the department, even if the said information is disclosed. Okay, this court takes a serious note of the 2-year delay in releasing information, the lack of adequate reasoning in the orders of public information officer and the appellant authority, and the lack of application of mind in relation to the nature of information sought. The materials on record clearly show that legal side approach of the second and third respondents in releasing the information sought. However, the petitioner has not been able to demonstrate that they mollifiedly denied the information sought. Therefore, a direction to Central Information Commission to initiate an action under Section 20 of the Act cannot be issued. This is what
Okay.
highlights of the.
We have one question. A person is asking if my 498 case is running in Andhra Pradesh, but he want to file TEP in Bangalore. Is it possible?
Yeah, we can file anywhere. But the actually earlier we also discussed the area of the income tax department is compulsory. Hello.
Yes, continue. Thank you.
Yeah. These are the useful citations for TEP. Useful judgments while filing. Yes.
Bala, let me tell something about one case. I got the earlier this thing because he filed in his place the TEP complaint.
Okay.
And they return the complaint saying his PAN card jurisdiction is not with us, the father-in-law's jurisdiction. They asked him to file in his father-in-law's jurisdiction.
Yeah, that is what, sir, I told.
Yeah, no, I replied in chat also. So
okay.
That's why I'm clarifying again, because most of the time, because they don't have local data, even if it's centralized, they say no, they don't want to take any responsibility or forward it to other department. They just return it, say, and is not coming under our jurisdiction. You go and file in because it's a different state.
Yes, sir. The DG80, Deputy General of Income Tax Investigation Department, every state having own office.
Yes. So if father-in-law is in his residence is in Andhra,
yes,
and the husband is in Bangalore, he cannot file in Bangalore. He has to send complaint in Andhra only, because wherever his jurisdiction.
Yes, correct.
Yes. So in that case, we can the person can file on the central level, that is going to CBODT, and CBODT will transfer to the respective state.
Yeah, that is the lengthy process.
Yeah, that is the lengthy process, but that is a sure shot process.
Correct.
Yeah, you can send a copy there also, but if you know the jurisdiction and other things, why to take double this thing? You can send a copy there and one send copy to Andhra or wherever the father-in-law resides.
Yes, however, we are suffering the duration of the TEP. Again, why should we take too much long distance? Again, we have to send centralized. Again, they have to forward it to our jurisdiction. Yeah.
Yeah, so we can send to our local department, local state, and if if needed, we can send a copy of the same to other state,
Yeah, putting a
central
CC
one
to
and the other state as well.
yeah, putting a CC to central level, that is a good.
Yeah.
Okay.
Yeah.
Yeah,
So that
continue.
will create an impact and the yeah.
Yeah, but the useful judgments while filing the TEP, all judgments are available in MyNation document system. Yeah, I have attached here almost 24 5 judgments, case to case. Useful judgments while filing the TEP. In-laws should disclose source of income for the extraction claims in 498 DV cases regarding false dowry allegation, interpretation of the state by Delhi High Court, party Srimati Neera Singh. This is a very useful judgment. First of all, we have to attach this judgment including our TEP application while filing the TEP to Income Tax Department. Useful judgments while in filing the TEP plus RTA. TEP investigation and outcome must be provided to appellant. Sri Om Prakash Singh, New Delhi, so on so. CIP to disclose the board outcome of the TEP to the appellant in 4 months' time. In 4 months' time, there is a judgment for that. TEP investigation and outcome must be provided to the appellant in 3 months' time, and CPO IO must provide the information and CRPC 91. There is a judgment. TEP investigation should not and infinitum and that it should be concluded in a reasonable time frame. There is a judgment. We can use all the judgments while we are shooting the RTA. Income tax department should provide the father-in-law income tax details. TEP should finish within 3 months. Judgment I'm moving the next slide. Judgment from Central Information Commission, where Information Commission allows the similar petition TEP information allowed and cannot be said to be a personal matter of the tax evader, not exempted under 8.1 of the RTA Act. Judgment from Central Information Commission in wide decision number 174 ICA oblique 2006, where Information Commissioner allows the similar petition TEP information and its outcomes should be disclosed, not exempted under section 8.1 of the RTA Act. Judgment from Central Information Commission CAC oblique 80 oblique A 2008 01389, where Information Commissioner allows the similar petition RTA of dowry matter allowed and hereby directed to disclose the above mentioned, not exempted under section 8.1 of the RTA Act. Judgment from Central Information Commission CAC oblique SG oblique C oblique 2009 oblique 000702 oblique 4128, where Information Commission, where he defines the concept of privacy, fundamental right of the complaint as provided under Article 21 of the Constitution. Judgment from Central Information Commission in CAC oblique WA oblique A 2007 0064, where Information Commissioner explain about the sensitive personal data, means personal data consisting of information. Judgment from Central Information Commission in so and so, where Information Commissioner allows the similar petition TEP information allowed related to dowry and not exempted under section 8.1 of the RTA Act. Judgment from Central Information Commission so and so, where Information Commissioner allows the similar petition TEP information allowed related to, okay, it is duplicated. Okay, judgment from Central Information Commission so and so, where the Information Commissioner allows the similar petition 8.1 acts. Okay, judgment from Central Information. There are so many citations to related TEP. We can use all the judgments for our benefit only. All the benefit. There are I have here mentioned almost 18 judgments. 18 judgments to get the RTA. Any questions?
Yes, one question came.
No question.
It's sorry, one question is there. So it's a
Vikas,
related
go
question
on.
which we already answered. Can we send a TEP complaint to CBODT and state separately?
Already answered.
Yes. Thank
Actually,
you.
here I want to add like what's internal to IT department actually happens, because I am aware of all that knowledge. What I have been said by one of the senior officers is every complaint goes to the same central division, which again actually redirects it to where it has to be sent to. Even though you actually take care of the PAN number and its IT related department, but the complaint actually goes to the central division, which actually sends it to where his PAN card is actually like whoever has the jurisdiction over that. So it should not be a problem if they file it either in the place where 498 has been filed or in the place where his IT returns are being done every year, like father-in-law's IT returns.
Yeah. Thank you. Thank you very much giving this opportunity.
You finish, Bala?
Yes, sir. Fine, sir. Finish it, sir.
Okay, thank you.
Thank you very much.
Bala,
Next.
we have just one more question.
Yeah.
OP being paid 45,000 in cash by school, can we file something against the school? I think this is related. Is this related to tax exemption?
No, it is not related to tax evasion. Yeah,
Could be
tax
for
evasion already
maintenance
we
or
discussed.
yeah.
We discussed it is related to fill and knife only.
Okay.
Yeah. Thank you. Thank you very much.
You can actually like.
Thank you, Bala.
Next speaker is Mr. Parasar Garu.
I'm there.
Okay. I will give little bit information about Dr. Sarvapalli Prasar. So Dr. Sarvapalli Prasar, he is a dentist by profession. Then he turned to legal consultant. Currently pursuing his final year LLB with a special interest in matrimonial matters. So today he is going to talk about the interrogatories. So I would like to welcome Mr. Sarvapalli Prasar to start his presentation. Thank you.
Thank you, Dr. Vikas Singh. Thanks for a wonderful intro. Right, Dr. Vikas, should I share the slides or will you share it?
Wait.
Right. First of all, let me talk about the disclaimer. The content on this site, including free advice, etc., they are for your personal information only. It's for using your personal discretion. It is not intended for trading purposes or carrying out legal proceedings. Right? It's just for using your discretion. We don't claim any copyright on any of these articles. Next slide, please. Right. First of all, in a civil case, like which includes the, if we restrict ourselves to matrimonial matters, what are the civil cases here? One is CRPC 125, the other one is a domestic violence case, third one is like matrimonial issues like divorce matters either under Special Marriage Act or under Christian Marriage Act or Muslim Dissolution of Muslim Marriages Act or under HMA, Hindu Marriage Act, or under Hindu Adoption and Maintenance Act. Once a petition is filed, and then a written statement is filed after that as a response to that. Now, when the written statement is filed by the defendant, let's say the husband is the defendant here, and then either the petitioner or the plaintiff or the respondent or the defendant, after the written statement, they need some clarity. What do? The best way to see, let's say you're the defendant and you want to defend your case properly, you need some data. Number one. Number two, a pressure tactic. You want to you draft a wonderful written statement, ripping apart the case, but then you still feel there are some lacunae in your defense, and you want to fill it. What do? You file interrogatories. What is an interrogatory? Interrogatory means to ask questions or to make inquiry closely or thoroughly, where a party to a suit requires information as to facts from the opposite party, he may administer to his adversary a series of questions. Those questions are called interrogatories. They are delivered in order to ascertain the nature of his opponent's case, either for the purpose of proving or supporting his case, or for impeaching or destroying the case of the other side. Relevant case law, Raj Narayan versus Indira Nehru Gandhi, 1972, Volume 3, SCC 850. Next slide, please. The object of interrogatories is twofold. Firstly, to know the nature of the case of his opponent, and secondly, to support his own case, either directly by obtaining admissions. Now, what is an admission? The moment the opposite party writes something as a reply affidavit to the interrogatories, it becomes an admission. It can be used as evidence against the opposite party, or by indirectly by impeaching or destructing the case of his opponent. Relevant case law, Bhaktacharan Malik versus Natarar Malik, AIR 1991, Orissa, ORI 319. The power to allow interrogatory should be exercised liberally without being restricted by technicalities. Relevant case law, Raj Narayan versus Indira Nehru Gandhi. Next slide, please. Now, who may administer interrogatories? Interrogatories may be administered by one party to a suit to the other party. Thus, a plaintiff or a petitioner may administer interrogatories to a defendant. Likewise, a defendant or a respondent may administer interrogatories to a plaintiff. So, it is a double-edged sword, mind it. But you should know how to use interrogatories. A party may object to answer an interrogator if it is scandalous, irrelevant, malified, immaterial, privileged, etc. Next. Rules as to interrogatories. Interrogatories may be administered in writing with the leave of the court and subject to such conditions and limitations as may be prescribed by it. The particulars of interrogatories proposed should be delivered to the court, which shall be decided by the court within 7 days from filing the application. Remember that the moment you file the moment you file your written statement, as let's say you're a defendant, the moment you file a written statement, the details of how, and let me take you back to the previous webinar of written statement. When you have filed a written statement, right? Written statement has to be drafted really, really well, and that's the first nail in the coffin, right? The second nail is your interrogatories. Interrogatories, when you give interrogatories, the court has to decide on the interrogatories whether to allow or dismiss the interrogatories within 7 days. That is the law. Interrogatories may be administered by the plaintiff to the defendant or by the defendant to the plaintiff. Interrogatories may also be administered by one plaintiff to another plaintiff or by one defendant to another defendant, provided there is some question or issue between them in the suit, action, or proceeding. Because sometimes it so happens that your own person may turn against you. In such scenarios, you have to use the power of interrogatories to bring out the truth, right? No party can deliver more than one set of interrogatories to the same party without an order by the court. In exceptional cases, a court may allow more than one set of interrogatories to one and same party. Next slide, please. Rules continue. Interrogatories which do not relate to any matter in question in the suit should be deemed to be irrelevant. See, you are talking about a particular topic, and then you suddenly come out an interrogatory with an entirely different topic. Court will not allow it. Interrogatories cannot be allowed at a premature stage. So what does that mean? See, the law is interrogatories should be filed only after, let's say you are the plaintiff, you can file an interrogatory only after the written statement is filed or the time period for written statement is over. Number one, if you are the defendant, you will not be allowed to file interrogatories till your written statement is filed. Interrogatories may be objected on the ground that they are vexatious, scandalous, irrelevant, unreasonable, not bona fide to the questions raised in the suit, injurious to public interest. Interrogatories may be set aside on the ground that they have been observed, administered unreasonably or vexatiously, or struck off on the ground that they are prolix, oppressive, unnecessary, or scandalous. Any party to the suit at the trial of the suit use in evidence any one or more of the answers or any part of an answer of the opposite party to interrogatories. Where any person fails to comply with an order to answer interrogatories, his suit can be dismissed if he is a plaintiff, or his defense can be struck off if he is a defendant. That's how powerful your interrogatories are. Next slide, please.
We have one question.
Yes.
Can interrogatories can be filed in appellate court?
An appellant court, I'm not sure. I don't think so. Because you cannot adduce new evidence in appellate court.
Okay.
I'll get back to him.
Thank you.
Next slide, please. Interrogatories which do not relate to any matter in question in the suit should be deemed to be irrelevant. I think I repeated that slide. Next slide, please. Interrogatories which may be allowed. As a general rule, interrogatories can be allowed whenever the answers to them will serve either to prove the case of the party administering the interrogatories or to destroy the case of his adversary. The right is a valuable right and the party should not be lightly be deprived of that right. So when you administer interrogatories, it is a valuable right and the court has to allow it unless it falls in the criteria of the criteria of where it should not be allowed. Right? Relevant case Ram Lalaso versus Than Singh, AIR 1952, Nagaland 135. The power of interrogatories therefore should not be confined within narrow technical limits and must be exercised liberally so as to shorten litigation, save expenses, and serve the ends of justice. See, boss, understand this. The typical objection that your opposite advocate takes, that when you file an objection, when you file your interrogatories, this is nothing but a delay tactic. Whereas the actual purpose of interrogatories is to shorten the litigation. You file an interrogatory, court has to decide it in 7 days. Once the court allows the interrogatories, the opposite party has to answer it in 10 days. Where is the delay? It actually shortens the litigation, save expenses to both the parties, and serves the ends of justice. Interrogatories must be directed to facts related to any matters in issue. So what is a matter? The expression matter means a question or issue in dispute in the suit and all the thing about which a suit dispute arises. Relevant case law. Union of India versus Ibrahimuddin, 2012, 8th volume, SCC 148. They need not be directed directly to the facts in issue. It is sufficient if they are relevant to the matters in question in the suit. Relevant case law. ML Sethi versus RP Kapoor, 1972, 2nd volume, SCC 427. Next slide, please. Interrogatories cannot be disallowed on the ground that the party interrogating has other means of proving the facts in question, since one of the purposes of interrogatories is to obtain admissions from the opposite party. Relevant case law, Nishi Prem versus Javed Akhtar. I think we are done. Interrogatories which may not be allowed. Now, all the while we sought interrogatories which can be allowed. Now we will say interrogatories which may not be allowed. Interrogatories which do not relate to any matter in question in the suit should be deemed to be irrelevant. Interrogatories cannot be allowed at a premature stage. Interrogatories may be objected on the ground that they are vexatious, scandalous, irrelevant, unreasonable, not bona fide to the questions raised in the suit, injurious to public interest. Interrogatories may be set aside on the ground that have been administered unreasonably, vexatiously, or struck off on the ground that they are prolix. Prolix means irrelevant, too early, too short, not clear, oppressive, unnecessary, or scandalous. Interrogatories for obtaining discovery of facts which constitute exclusively the evidence of the case of his adversary. You cannot ask you cannot file an interrogatory to ask the evidence, exclusive evidence of the opposite party. It is to clear your doubts and to strengthen your case or weaken the case of the opposition. The purpose of interrogatories is not to enable a litigant to come into the court knowing how his opponent is going to prove his case. Relevant case law. ML Sethi versus RP Kapoor, 1972, Second volume, SCC 427. Interrogatories which are really in the nature of cross. This is not a cross-examination before a cross-examination, boss. Interrogatories which are really in the nature of cross-examination will not be allowed. Relevant case law, Raj Narayan versus Indira Nehru Gandhi, 1972, third volume, SCC 850. Next, non-compliance, appeal and revision. Now, what happens when...
Professor, we have two questions.
Yes.
Can we take them now? Yeah.
Yes.
Can interrogatories be filed even before final arguments? If not, till what time? Of course, like after filing written statement, can interrogatories be filed?
He has to try it. He has to show why it is important. Because cross-examination is already over. What will he do with those interrogatories?
Interrogatories can be filed before final after cross-examination?
Maybe he can file it to get this thing. He has to try and he has to convince the court why he needs those interrogatories.
Okay. So when is the right time for interrogatories to be filed?
Immediately after written statement.
Okay, immediately after filing WS. And there is another, the best option, interrogatories or deposition?
Interrogatories or what deposition? Okay, let me put it this way. You file a written statement. Okay. And then you need to collect, you need some more data to support you to prepare for your cross-examination better. So what do? You shoot an interrogatory, get the depositions that you wanted, you can use it in your cross-examination to weaken the case, either to weaken the case of the opposition or to strengthen your own case.
Okay. And there's another question. Which stage can be said premature? I think this is from from the webinar. Somewhere you mentioned it is actually quite premature. So what stage in the case can be considered as premature for filing?
Before filing written statement.
Before filing. Okay. Yeah, Professor.
Whereas any person omits to answer interrogatories, the party administrating interrogatory may obtain an order from the court requiring him to answer by affidavit or by oral examination. Viva voce. Relevant case law, Union of India versus Ibrahimuddin, 2012, 8th volume, SCC 148. Appeal. An order granting or rejecting prayer for interrogatory is neither a decree nor an appealable order. No appeal therefore lies against such order. So, let's say you are the person administering the interrogatory. The moment interrogatories are granted, opposite party cannot go for an appeal. Right? The same way your interrogatories are rejected, you cannot go for an appeal. Right? Next is revision. Though an order granting or refusing interrogatories may be said to be a case decided under section 115 of the Civil Procedure Code, since it is in the discretion of the court to allow or to disallow interrogatories, High Court normally does not interfere with such order unless it is clearly wrong or illegal. So if you want to go for okay. Further reading material. Important case laws about interrogatories. Raj Narayan versus Indira Nehru Gandhi, ML Sethi versus R.P. Kapoor, Union of India versus Ibrahimuddin, Ram Lalaso versus Tan Singh. So if you read these four case laws, you will understand interrogatories better. These are my details. S_Parasar is my Twitter ID. Email ID is surveypallilegal@gmail. So next topic would be interesting. Stay tuned for discharge under section 239 of Criminal Procedure Code. That's it.
Yeah, Professor. Actually, those two questions were further clarified. What Gaurav actually meant is, are there any drafts clearly suggesting that this interrogatory can be filed and this cannot? Like, are there any set of guidelines for that? Like, what can be considered in an interrogatory, what cannot?
See, I'll tell you what it is. Frankly speaking, it is a discretion of the court.
Yeah, right. And comparing it with the RTA, like whatever the RTA right that we have, where we can actually fetch the same amount of information. In comparison to that, can you actually clarify?
RTA takes 30 months. I mean, 30 days. Sometimes
30 days.
Opposite part, 30 days, and then you don't get the information, and then you can file for. You can have to wait for another 45 days. plus another 10-15 days of postal delay. So it's totally about 3 months. Whereas as per law, the court has to decide on the interrogatories within 1 week, and the opposite party has to what do we call it? Opposite party has to do this thing, has to reply to it within 10 days. So taking that in this perspective, interrogatories are a faster way than RTI, at least theoretically speaking.
Okay. Yeah, and related to the premature, it's actually meant in cross-examination, as you have already referred in your webinar, that it cannot be a cross-examination prior to the actual cross-examination stage in the case. So interrogatories cannot be put before cross-examination, like
No.
prior to.
See, the point is, there's a difference between collecting evidence, see, there's a thin line between getting information and cross-examining the opposition. Right. Let's say, let me give you an example. Let's say there is a suit for civil defamation claiming damages, and then the opposite party says that they want a lakh of rupees as a compensation for defamation. Right. Now, when you ask the opposite party to explain why the reason why they want that 1 lakh, their reasoning, it's almost like cross-examination. You cannot ask that question in interrogatories. Right. So interrogatories is something which is something to prepare the base for cross-examination. You need some data. Let's say there is a domestic violence case, and then the opposite party says, I was harassed in the matrimonial home. And then, but she doesn't say what is the matrimonial home. Husband is staying in a particular place. Husband's parents are staying in a place. Husband is staying in place A. Husband's parents are staying in place B. And the wife is staying in place C. Wife's maternal home is place C. And the wife says, I was harassed by my husband I was subjected to domestic violence by my husband in my matrimonial home. Now, what is the matrimonial home? There is no clarity.
Yeah, agree, Professor. There's one more question. If the court fails, because we were more inclined towards interrogatories rather than RTI, assuming that the responses will be much quicker, and in the case of valid interrogatories. So if the court fails to decide it in 1 week, the question is, I assume, can we place a request to do so? Like, can we
Defense in cross-exam. I have a network issue. Hope I'm audible.
Yeah, we can hear you now.
Right. Or to strengthen your own case in defense, then you can administer an interrogatory asking for clarification of what the petitioner or the applicant means by matrimonial home. So to get some clarity. So these sorts of things will help you to strengthen your strengthen your either your defense or weaken the case of the opposition. Right. Any more questions?
Yeah, the last question is, can COVID times be used as delay a decision on allowing interrogatories? So, yeah, how is COVID impacting the normal process of interrogatories?
Of course. But then you have to start somewhere. You finish off your work, and then we'll see about it later. Because if you delay, as it is, there is a delay, and then you take that excuse and even for delay, that led to further delay. That will cause further delay. Draft your interrogatory, shoot it, let the court decide.
Okay. And we have a few questions in the generic way. There is a question from Ashish. He says, like, family court said it will pass an order on his IA, but actually passed an order on the main HMA 24.
How did the family court say? Did it say orally or what?
I think it passed an order in the actual main petition, HMA 24, when there is order not yet done on the IA, which is filed in that case.
Yes. Go for revision because it is illegal.
Yeah, that's what, like, it should not be the process. Yeah.
That should not be the process. Because he filed an IA to get data to oppose the HMA 24. Now, instead of allowing it, instead of deciding the IA, and that's actually a violation of his principle of natural justice. Am I audible
Actually, he
or
appealed in High Court. Yeah. There are
okay?
a few set of other questions. So he appealed in High Court, making it as one of the ground, like they have actually given an order in the HMA 24, even when there is an IA pending, and he's just asking what can be expected from High Court, as this is actually a violation of the rule of natural
Principle of
justice.
natural justice. Yes. This particular thing, we cannot guess what the judge is thinking, right? Right.
Okay, but yeah, there is because it's quite again, like, considered as a violation. They can redirect for the IA to
Decide that
be
first.
actually reserved for orders first.
Yes.
Panda asks for any sample on these interrogatories so that we know, like, what formats can be accepted, how to frame the questions, and so on.
I'm working on
Where
it.
to
Once
actually
I'm
make
ready,
best use of it.
where he can use wherever he wants.
Okay.
Like
Can we ask
except because
question about
you cannot.
contradictions made in 498 and DV to ask which one is correct? Because most of the cases will be like copy paste, but sometimes if at all, if that copy paste also had the new editions, addendums, then yeah, they will be contradicting their narration from 498 to DV to 125 to diverse.
That's a very good strategy. But let him check with his counsel because the counsel would have had some. See, there are two things here. One is the surprise factor. The other one is the preparing your defense. Right. So we don't know what strategy his counsel has taken up, is going up with, but that's a very good strategy.
Okay. There's one question. What is the difference between interrogatories and protest petition?
Protest petition is filed in criminal cases. Interrogatories are filed in civil cases. There you go.
We actually mentioned, I think Gaurav Gupta has mentioned it as a concern. Not deciding interrogatories should be considered as illegal. Is this like a violation of the principle of natural justice, or
Of course, see what is the principle of natural justice. You should know. Here, both the parties. Number one. Number two is what did he do? He see in order to defend his case, he gave a list of interrogatories. The court should either allow it or dismiss it. If the court dismisses it, and if the person administering the interrogatories feels that it is illegal, then he can go for revision to high court. It is neither allowed nor destroyed, but then the main case is disposed of. But then the HMA 24 is disposed. So it is nothing but dismissing his defense. He was not even given a chance to defend his case properly.
and is there any limit on the number of questions that we can pose, or
Nothing.
a certain format? Okay.
Format, even I'm working on it. Once I'm ready, I'll definitely share it.
Another question is, DV is quasi-criminal. Can we file a protest petition in DV? Yeah, like
Protest petition for what?
no. We mentioned protest petitions should be filed in civil and
Protest petition in criminal. DV.
yeah, sorry, in
The
criminal
point is,
and
interrogatories in civil. In DV is, see, except for section 31, as per several judgments of various high courts, except for section 31, everything else is civil in nature. Though it follows CRPC, the magistrate who is presiding over the case can form his own rules, which means that interrogatories can be used in DV because the relief sought are civil in nature.
There's one question on like what sort of questions will be accepted in the interrogatories. Can I seek information on date and time of incident when only date is mentioned, like not time or like more specific,
try.
precise details
can
are
try.
not mentioned?
He can definitely
Oh.
try it, but he has to convince the court that this is something which is not cross examination.
Understood. Yeah, that's all, Parasar, from YouTube. If at all there are questions from our group internally, I can take them.
One question is there from Shriram Yadav. If a person invests in Hundi, can we file TP against the person? I don't know Hundi is legal or not. What is Hundi?
It's like a donation attempt.
Is it a donation or is it some sort of Havara transaction?
Nah,
This
nah,
question from
Hundi is like
Shriram Yadav.
dowry. Yeah, Hundi is like dowry itself over here.
Okay. Then he can, of course.
Okay, we don't have further questions. So we can conclude the session.
Yes, we can, I think.
Rudy sir, are you there?
Okay. Thank you all for attending today's session. So we are winding up over here.
Thank you, Parasar sir.
Thank you, Dr.
Thank-
Vikas. Thanks,
Thank
everybody.
you, Murthy sir.
For
Thank
being with
everyone
us.
to join. We will meet in next Sunday. Thank you. Bye.